All rise. Veuillez vous lever. Please be seated.
Mr. Mladić, you may proceed.
Thank you, Your Honors. Before I proceed, I'd like to correct a misstatement that I made. When I said RM141 at temporary transcript page 54, I meant to say RM147. And that was brought to my attention by...
That's why I couldn't find it, Mr. Mladić. Please proceed.
Thank you. Your Honors, at transcript page 44,326, we heard Mr. Teager start the prosecution closing talking about the year 1993. But then you heard him say that Ratko Mladić joined the JCE in May of 1992. Then the prosecution's position changed yet again around transcript page 44,389 when they started talking about 1991, which predates the date that Ratko Mladić is alleged to have joined the JCE. And we heard at transcript page 44,373 that the prosecution would like to hold Ratko Mladić accountable for crimes in Croatia in 1991 and crimes in Bosnia in 1991. That was at transcript page 44,389 and the next page. After all this time, Your Honors, my client, Ratko Mladić, still does not have a fair and adequate notice from this prosecution of what exactly is their case against him and what time period and alleged events it covers. I ask Your Honors and the public out there, is this fair? This past week, Mr. Teager spoke about Rule 73 bis D and the defense arguments as to the indictment. In doing so, he confused two separate issues. One is the unfairness of incidents that were removed from the indictment by the crossing off of them by the prosecution under Rule 73 bis D. The other category are those things that were never properly written into the indictment in the first place. The prosecution also confuses the concept of preliminary motions to fix the indictment and the situation we are at now, where we are saying that no conviction can stand when the evidence presented is not in line with the indictment as specified. The law of this tribunal states that the accused cannot be expected to engage in guesswork in order to ascertain what the case is against him. Nor can the accused be expected to prepare alternative or entirely new lines of defense because the prosecution has failed to make its case clear. The Simic Appeals Judgment, paragraph 71. Further, the prosecution is expected to know its case before it goes to trial and cannot omit material aspects of its main allegations in the indictment with the aim of molding the case against the accused in the course of trial, depending on the evidence. Both the Georgievich Appeal Judgment at paragraph 573 and the Simic Appeal Judgment at paragraph 71 talk about this. Now let's focus on what Mr. Teager told us Monday. He told us that the crossed off parts of the indictment are out and that the parts that are empty and were never written in the indictment are still in. That was transcript page 44,384. But under such logic, then a blank sheet of paper would suffice as a proper indictment, and that surely is not in accord with the jurisprudence. But more importantly, given what Mr. Teeger said, then why are these crossed out, dropped incidents of the indictment back in the prosecution's final brief? On Monday, Mr. Teeger spoke of Croatia in 1991, and again suggested Mr. Mladić's involvement in crimes in Croatia. None of that is in the indictment. We complained to you at the pretrial conference about this, at transcript page 326 to 327, and asked you to prevent this. Your Honors denied that request by saying that only the indictment can charge the accused, and no material changes could be made in other ways, but that temporal events beyond the scope may be necessary for terms of context. And then we had the prosecution case. And at the close of the prosecution case, we found out rather than context, they actually wanted to use 1991 Croatia crimes for substance in the case. And we again complained to Your Honors at transcript page 20316, 20320. And Your Honors opined as to the extent for which outside temporal events can be used for context. But now the prosecution wants criminal responsibility for the same. To date, we have not had any type of protection from the rules of this tribunal as to notice and pleading requirements to know what this Croatia evidence is. Can Mr. Mladić be convicted on it? Then why wasn't it pled in the indictment? Similarly, RM 518 is being used as a Rule 92 quater witness, whom the prosecution is now presenting, not only for 1991 and Croatia, but for purposes of attempting to prove wholesale parts of the alleged overarching JCE. This is evidence from a 92 quater witness, admitted in written form only, and if uncorroborated, according to the law, it cannot be used as a basis for conviction. Look, for instance, at the Mladić trial judgment, volume 3, paragraph 243 for this type of ruling. And yet, in the prosecution's final trial brief, RM 518's evidence is cited 17 times. 5 citations are completely uncorroborated. That's at citations, the footnotes 765, 769, 771, 773, and 794 of the prosecution's brief. And 2 citations do not support the prosecution's averments in the final brief. That's at 9 and 963 footnotes. Neither the pretrial brief nor the 65 terse summary indicated fully the manner of how RM 518's evidence was going to be presented to prove material elements. Some of the averments in the final brief of the prosecution relate to direct acts and conducts alleged of the accused via this uncorroborated 92 quater witness. Is that enough for a conviction? No, Your Honors. Now, even more strangely, we heard from Mr. Traldi at transcript page 44399 that even unscheduled incidents can corroborate the evidence. And so under this logic, I suppose even the crossed out portions, as well as unscheduled incidents, can be relied upon according to the prosecution. The prosecution position on Rule 73 bis D is contrary to ICTY jurisprudence on the issue. Other ICTY cases have clearly held that the prosecution is not permitted to lead evidence on parts of the indictment that are excluded under Rule 73 bis D.
Mr. Mladić, just for the record, Did you say on page 61, line 4, that even scheduled incidents can corroborate, or did you say unscheduled incidents?
Well, Your Honor, I meant to say unscheduled, but to be honest, if I may have said scheduled, so thank you for catching that. I meant to say unscheduled incidents.
Thank you.
Under the jurisprudence, unless the strike that. Let me start at the beginning of the line. Other IC2I cases have clearly held that the prosecution is not permitted to lead evidence on parts of the indictment that are excluded under Rule 73 bis D unless the prosecution applies for such evidence to be heard and included under Rule 73 bis F and obtains a court decision permitting same. That was not done here. In the Mladić et al. Trial chamber, after submission of the parties, pursuant to Rule 73 bis D, to limit the prosecution indictment, the charges in relation to Račak, Padalište, and Dubrava prison were removed. Thereafter, in that case, the prosecution attempted to lead evidence which related to Račak and Padalište, and at trial the chamber intervened and prevented such backdoor attempts to get around the Rule 73 bis D decision. And in this case, we are having the prosecution trying to revive counts, incidents that were crossed out. Now, according to the tribunal statute, General Mladić is to be treated equally with others that have been before him at the ICTY. And thus we submit that his rights should not be curtailed or diluted in relation to the ability of the prosecution to proceed with either unindicted, unscheduled matters that are not in the indictment, or matters that were in the indictment but were removed from the same by the application of Rule 73 bis D. And focusing on how the prosecution applied 73 bis D to our case, when it moved for reduction of the charges under the rule, the prosecution promised that if it sought to later lead and rely on evidence from the dropped charges for mens rea, it would give specific notice in the Rule 65 terse summaries before leading the same. It failed to do so, and now is relying upon evidence in the final trial brief for no fewer than 2 of the dropped detention facilities in Sokolac, C18.1 and C18.2. 4 dropped detention facilities in Kotorvaros, C11.1, C11.2, C11.3, C11.4, and 5 dropped detention facilities in Sanski Most, C17.1, C17.2, C17.3, C17.4, and C17.5. That's in total 11 previously dropped detention facilities. But Mr. Teager told us everything that's crossed off in the indictment is out. So which is it? The prosecution wants to have everything that is missing from the indictment, everything that was crossed out and dropped, and everything else. How is Mr. Mladić supposed to know what to defend against in such a scenario? This is not a hypothetical or academic exercise, because I will now tell you that at the prosecution's final brief, at paragraph 1235, there are 8 completely new charges for destructions of mosques for whom criminal liability is claimed as to Srebrenica. These are nowhere to be found in the indictment. How badly does the prosecution think it's doing Do they think they're losing? That they now decide to throw a surprise claim of mosque destruction to beef up their case? In the indictment, paragraph 59 states that the destruction of cultural sites is limited to Schedule D. Not a single mosque from Srebrenica is in Schedule D. Where's the notice? Do we now get to seek a reopening of the trial to try to defend these new charges? Is it fair if we don't get that chance? Will the prosecution try to raise new charges during next week's rebuttal, or perhaps at the judgment? There has to be a line drawn. It's supposed to be drawn in the indictment. That isn't all. When we look at Annex B of the indictment, as to other mosques, and compare it to the prosecution's pretrial brief, we find that the number of affected religious sites do not match up between the two in regards to Ključ, Kotorvaroš, Sanski Most, Vlasenica, and Ilica. Why are the numbers different? For which ones now do we have to defend? This is an untenable situation. Your Honors can correct all of this in the judgment by preventing this prosecution attempt and dismissing those charges. In our final brief at pages 6 to 9, we talk about other charges for which there is absolutely nothing written in the schedules about alleged crime sites. How can we be held in suspense until the very end of the case to know what it was that we were supposed to defend against? There are entire counts for which they have no notice in the indictment. This practice renders the notice provisions and protections of the tribunal totally meaningless. You have already heard from Mr. Lukic about how incredibly vague and nebulous and overexpansive the indictment was as to JCE. Your Honors may recall some discussion at the beginning of the case that the prosecution could not provide more details. Perhaps if you've read the prosecution's final brief, you were perhaps shocked, like we were, to find in the final brief that they now know precise names and positions of persons whom they allege are members, direct members of the JCE, who are not pleaded with particularity in the indictment. Look at Srebrenica, for example, paragraphs 1066, 1081, 1086. There are likely, I think, a dozen or so names that are never specified in the indictment and are for the first time formally identified as JC members in the final brief. Is that fair? Some of these persons were prosecution witnesses who denied any part of the JCE. How is the defense to have fair notice to do its job? On Monday, during one of the breaks in the proceedings, my client asked me, Danny, will President Karadzic be coming here later to defend himself against Tiger, or do we have to defend President Karadzic in our closing too? Indeed, Your Honors. I understand and appreciate that Mr. Tiger was in the Karadzic case longer than he was in the Mladić case, and that he may be stuck in that mindset. But I'm also conscious of another possibility, namely that the prosecution is trying to play on the emotions and institutional knowledge of your staff members, your helpers, who came over from the Karadzic case after drafting that judgment which convicted Mr. Karadzic, and which in its text tried to convict Mr. Mladić, and are now drafting the judgment already as we speak in this case. Clearly, the prosecution are trying to manipulate things in that way. Now, we have mentioned a few times duty of candor. Since it is called by different names in different jurisdictions, I want to spend some time on that to make sure we all understand what I'm talking about. Under United States law, candor is a duty that has long existed for prosecutors, which is best explained by the 1935 case of Berger versus U.S. If I can have the next slide. And in that case, you see the holdings that are up on the screen. And the key there is that the interest of the prosecutor is not that it shall win a case, but that justice shall be done, and that they should refrain from improper methods calculated to produce a wrongful conviction. Now, under U.S. law, the duty of candor has been applied to raise and punish serious questions of prosecutorial misconduct, including for taking two inconsistent positions in two separate criminal proceedings against two accused. Smith v. Grouse, 205 F. 3rd, 1045, a case from the 8th Circuit, 2000, is one such example. Such a duty extends to informing the court correctly about the law and facts of a case so that the court may arrive at correct conclusions and render exact justice. Per the U.S. Supreme Court in Brady v. Maryland, 373 U.S. 83, 1963, society wins not only when the guilty are convicted, but when criminal trials are fair. Our system of the administration of justice suffers when any accused is treated unfairly, end quote. Respectfully, the duty of candor does not allow the prosecution to stay quiet about and thus conceal material facts and law that may assist the chamber in not being misled. We have not performed an exhaustive review of the world's legal systems, but can report that we have found such a duty exists under various names within the United Nations, Canada, Britain, Australia, South Africa, Kenya, and Ireland. If we can have the next slide, please. Here we see from the guidelines on the role of prosecutors adopted by the 8th United Nations Congress on the prevention of crime and the treatment of offenders from 1990. Again, language similar to what we looked at before. If I can have the next slide. And again, from the Canadian jurisprudence, in Rex v. Chemendy, 61 CCC 224 from 1934, that again, a criminal prosecution is not a contest between individuals. It is an investigation conducted without feelings or animus on the part of the prosecution, with a single view of determining the truth. Your Honors, I respectfully submit that some of the prosecution's tactics and things that have happened in these proceedings need to be viewed through the lens of the existing duty of candor, including what I've already spoken about. I would highlight the following. In regards to Prijedor, which we will discuss later, there is an issue in that the prosecution is presenting faulty evidence and incompatible theories in this case, which is different from other convictions and cases it has pursued. In those other cases, the perpetrators were civilian MOOP and now are being recast as VRS. We will explore that further when I get to Prijedor, but for now, I will mention that in paragraph 33 of the prosecution's final brief, it is presented that Mr. Mladić is involved in the running of the camp's Omarskan care term, and that Mr. Mladić was responsible for cleaning up the camps before a Red Cross visit. However, in evidence, we have P2432, which is testimony under seal of a protected prosecution witness, where in that exhibit, the prosecution, in fact, Mr. Teager, is presenting that witness and is presenting the evidence that Zhuplinin, rather than Mladić, was the one that ordered these facilities cleaned up before the ICRC came, and that Durlacha of the civilian MOOP ran both centers. Is their case that bad that they must recast history and take diametrically opposed positions to try and get convictions of two persons for the same deed? But let's get back to Srebrenica. Let's recall that the prosecution started in the opening talking about 7,000 dead at Srebrenica. At trial, the demographers kept creeping that number upwards. But let's recall that the prosecution demographers did not initially reveal that 70% of their purported victims for the Srebrenica incidents were ABIH soldiers. Defense expert Mladić at transcript page 38170 explained that. Let's recall there are unresolved issues about some of the victims exhumed from the Srebrenica mass graves who are recorded as having been killed as members of the ABIH in the years prior to 1995, D344 in evidence. And we talk in our final brief at paragraph 2262 to 2263 of the failure of the OTP to account for their own body of evidence from survivors of the Srebrenica column and from their own expert, Richard Butler, to talk about massive combat casualties of the column. And you can find that at our defense brief, paragraph 2264, and transcript page 16289 to 16290. So where are these dead, these combat casualties? And are they included in the figure being promoted by the prosecution? And now if we could briefly go into private session.
We move into private session.
Back in open session, Your Honor.
Thank you, Mr. Registrar.
Your Honors, at paragraph 1581 of the prosecution's final brief, the prosecution has now reduced the figure of victims for Srebrenica to 5,956. Yet, the other day, in closing, Mr. McCloskey again promoted it to over 7,000 victims. Keep in mind the prosecution and their demographer have refused to provide the defense with matching criteria and insight into how their demographer made the matches to identify all these victims as being related to crimes in Srebrenica. This is a case that the prosecution must win and get a conviction in. That's their position. It's a case where General Mladić is vilified in the media. It's a case where President Miron of the MICT has assured victims publicly that Mr. Mladić will be brought to justice, and one where President Adjus of the tribunal has already convicted Mr. Mladić of crimes in the Popović judgment, absent Mr. Mladić being able to defend himself. The political pressure to convict is great, but duties must not be broken. Duties and the law must be applied evenly and impartially without regard for pressure of political or other nature. Now let's talk about Kalinovic.
Mr. Mladić, if you look at the screen, you are kindly requested to slow down.
Thank you, Your Honors, and I apologize. I should be looking at the screen. Let's talk about Kalinovic, General Mladić's hometown. This prosecution filed a motion seeking for you to take judicial notice of an adjudicated fact, I believe it was from the Mladić case, that 4 named mosques in Kalinovic were destroyed by Bosnian Serb forces. That's adjudicated fact 746. At the same time that they obtained your decision granting that request, the prosecution surely already had in their possession a report from expert Riedelmeyer from the Mladić case telling them that per his review, the 4th mosque never existed and thus never was destroyed. They do nothing. They bring a witness for Kalinovic, RM034, asking very little of him except for the leading question, who destroyed all 4 mosques in Kalinovic? And the witness confirms by saying all 4 mosques were destroyed by Bosnian Serb forces. The prosecution again keeps quiet. Then Riedelmeyer comes, and they choose not to ask him about Kalinovic and the mosque that doesn't exist. They keep quiet again. In Rule 98 bis, I raise it and point out that the mosque doesn't exist. At that point in time to today, they take no steps to acknowledge this or to seek to drop that charge for that mosque that doesn't exist. Is that how the duty of candor is supposed to work? Respectfully, Your Honors, for these reasons alone, any result other than an acquittal will be marred with a black stain of the prosecution's mishandling and disrepute, which then would forever mar the reputation and legacy of this tribunal. And since your names and your reputations will be affixed to this judgment, do not let the prosecution's foul behavior stain and blemish your reputations. Now I will move to count 1, the charge of genocide in the municipalities. In its final brief, the prosecution has focused its allegations of genocide solely on an analysis of the events which transpired in Prijedor. Again, on the other day, this week, they pushed Prijedor as the main example for their genocide case in relation to the municipalities. In doing so, they imply that they cannot substantiate a charge of genocide in the municipalities otherwise indicated in their indictment. Similarly, an analysis of this single municipality of Prijedor strongly undermines their assertion that a pattern of crimes existed across the 6 identified municipalities, which, according to the prosecution, evidences genocide. The other day, we listened to the prosecution say that the chamber may find that count 1 has been proven in the aggregate by taking parts from the best evidence from the various municipalities and then using that with Prijedor to draw conclusions of a pattern. No, that surely is not the standard. Cherry-picking the evidence is not the standard for genocide. If there is evidence contrary to genocide, then that is reasonable doubt. If a particular municipality charge is sought to be proven as genocide, it's up to the prosecution to prove that charge, not to aggregate a lot of bad evidence to link it by association with good evidence. The reason the prosecution wants you to do this is because it has led very little evidence on most municipalities. There's a lot that is open and unknown. Your Honors, that's reasonable doubt. That is not the top tip of the pyramid. That's somewhere lower. That is an acquittal. The specific intent, or the so-called dolus specialis, is what genocide distinguishes from other criminal prohibitions. This is an aggravated form of intent and requires not only intent for acts, but also intent to commit the acts for purposes of destroying in whole or in part a national, ethnical, racial, or religious group as such. The intent must be to destroy the group as a separate and distinct entity and target individuals because of their membership of a group. This specific intent cannot be established in this case. When reviewing actions and statements in their proper contexts, it shows there was no intent to destroy the Bosnian Muslims and Bosnian Croats that Mr. Mladić had in his mind. Your Honors, in his possession as main staff commander, General Mladić could have issued orders to commit horrendous crimes, but that is not what General Mladić did. On the contrary, he always insisted that the VRS abide by the Geneva Conventions and customs and laws of war. And most importantly, Mladić issued orders to protect the civilian population. We have multiple witnesses and documents that talk about that. But for example, on 23 June 1992, the accused ordered the Rogatica Brigade to take measures to protect the Muslim population in the villages of Burati and Vrhbarje from possible violence from individuals. That is D01514, page 1 to 2. Is this evidence of an intent to destroy Bosnian Muslims and Croats? No. Now, Your Honors, the prosecution claims that intent can be inferred from statements made by Mr. Mladić, and in making this claim, they would have you understand these statements out of their context and disregard any and all statements that evidence the contrary. They cannot do this. They have to take the statements together and review them in their context with all the evidence in mind. The Karadzic trial judgment, paragraph 550, says that. And we saw an example today where the full context of the third Fontana meeting is quite different from what was presented by the prosecution. Now, For example, the prosecution has misinterpreted Mladić's intent so much, to such an extent, as to impose language not used by him in order to prove dolus specialis. For example, contrary to what is alleged in paragraph 381 of their final brief, Mladić did not depict all Bosnian Muslims or Croats as enemies, let alone as historical enemies of the Serb people. Quite the opposite. In P00431, page 33, Mr. Mladić said, quote, "We don't want a war against the Muslims as people or against Croats as people, but against those who steered and pitted these peoples against us," end quote. The prosecution has similarly failed to contextualize the statement by Mr. Mladić that all actions were justified in the face of the threat of genocide. This is at 381 of the prosecution's final brief. And the report, the document in which this statement was made, was drafted in the midst of a conflict initiated by the SDA against the SDS and Bosnian Serb people in order to force them to accept SDA political dominance. In that context, Mr. Mladić praised the Bosnian Serb people for their resistance against the believed threat of subjugation and their progress towards establishing a democratic community in which people of all ethnicities would be equally respected. P1966, page 3. Furthermore, the prosecution has attempted to compile unrelated exhibits which have no association in an effort to substantiate dolus specialis in paragraph 381 of their final brief. When viewed in their proper context, none of the referenced exhibits of evidence show any intent to, quote, vanish, end quote, or, quote, disappear, end quote, any person based upon their ethnicity, let alone an intent to destroy Bosnian Muslims peoples in whole or part. Rather, references are made only to legitimate combat personnel who posed a threat as enemy combatant forces. For example, P1969, referenced by the prosecution in footnote 1550 of their brief at paragraph 381, Mladić states only that the Ustašas should disappear, and in P3076, Mladić is concerned only to have the enemy vanish, that enemy being the combat forces against which he is defending his people. Moreover, in making these compilations, the prosecution has also relied upon several documents which do not pertain to the 6 municipalities referenced in the indictment for genocide. For instance, P327 and P1960. The prosecution claims that genocidal intent can be evidenced from the satisfaction that Mladić is alleged to have expressed of the actions of fighters in Prijedor in an interview in October of 1992. That is paragraph 381 of the prosecution's brief. It should be noted that he does not reference the VRS. He states only, quote, their fighters, end quote. That's P7629, page 2 to 3. And what the prosecution fails to bring up in that same interview, Mladić also reiterates his commitment to peace, saying, and now I quote Mr. Mladić, "I would like peace to come already during this interview or immediately afterwards, but in my opinion, the problems will not be solved that fast. With regard to the army, we are ready to sit down and talk about peace right now. If the opposing sides demonstrate such will as well, peace would be possible and would be restored quickly. End quote. P7629, page 3. This reiterates statements made by General Mladić throughout 1992, including the intercept referenced by the prosecution, P327, page 2 to 3, in which Mladić says, quote, "We are not in favor of fighting, we are in favor of peace, period," end quote. As such, it cannot be concluded that he knew of crimes or that he approved of them from this evidence, as much more benign interpretations are available from the plain meaning of the words he used. A high standard must be met to evidence the intent to destroy. Indeed, it has been held that even statements which could indicate an ethnic bias or an intention to separate people based upon ethnicity, those mere words alone are insufficient to demonstrate an intent to physically destroy. At our own tribunal, we can look at the Mladić trial judgment, paragraph 519, the Karadzic trial judgment, paragraph 2597, and at the ICJ, the judgment in the case of Bosnia and Herzegovina versus Serbia and Montenegro, paragraph 190. Similarly, the prosecution would have us believe that any deaths, crimes, injuries, or other acts which occurred in the municipalities evidence genocidal intent. They have failed, however, not only to demonstrate Mladić's culpability for such deaths, crimes, injuries, or other acts, but also that the acts themselves evidence genocide. In fact, it has been demonstrated that no group was in and of itself deliberately targeted by the VRS. Evidence demonstrating that numerous civilians of all ethnicities were protected by the VRS, despite the incidents which occurred, that defeats the allegation of dolus specialis. That shows there was no intent to destroy the group in whole or in part in Mr. Mladić's mind. For example, in Rogatica and Kotrovaroš, several Muslim villages enjoyed full protection during the conflict. While the prosecution in their submissions would like to focus on Shatorovici, I would again return to the villages of Burati and Vrpolje. And in evidence is D1514, an order from the main staff and signed by General Mladić to the Rogatica Brigade commander. This order was issued after another document, D958, a report on how peaceful and loyal Bosnian Muslim villagers were being harassed by unknown persons. If I can have the next slide. Here we have it in both languages. In this order, General Mladić says, quote, "Immediately take measures to protect the Muslim population in these villages from possible violence from individuals because they express loyalty to the Republika Srpska. 2, explain to soldiers and units who will perform the possible effects nearby these villages or those who intercede terror, that any violence against the people of this village, of these villages, will be politically harmful for Republika Srpska, its army, and the Serbian people in general. 3, for execution of this order, unit commanders are personally responsible to me, period, end quote. The evidence is that these villages stayed peacefully with their Serbian neighbors until late into the war and left peacefully due to no reasons related to General Mladić or any JCE. The prosecution would have you believe that General Mladić has a discriminatory intent to destroy Muslims already in 1992, and yet that's exactly what he's issuing this type of order. General Mladić is acting to protect Bosnian Muslims, including from errant and wrongful acts of fellow Serbs. Your Honors, that's reasonable doubt. That is an acquittal. And in Sanski Most, there are neighborhoods with more than 1,000 Muslim and Croat inhabitants. That's D785, paragraph 19, as one example of that evidence. The prosecution took issue with this as well. And I would like to focus on another 2 of General Mladić's documents. They are D929 and D1503. And they are issued in September and October of 1995 and are addressed to President Karadzic and the MUP police minister. And they relate to Sanski Most. These 2 documents prove 2 things. 1, they prove that even in that late of a date in 1995 in the war, non-Serbs still reside in the very town of Sanski Most in significant number. 2, they show that General Mladić is standing up to try and protect those non-Serbs who are loyal citizens, who happen to be Bosnian Muslim and Croat, protect them from crimes and harassment by Arkan. As these documents demonstrate, General Mladić is neither approving of the harassment and crimes being committed by Arkan against non-Serbs, nor is he approving of Arkan and his group. He calls them paramilitaries and suggests that if the police and Karadzic do not act to remove this group, the army will act militarily against Arkan. One cannot turn a blind eye to affirmative evidence of General Ratko Mladić's actions to try and protect non-Serbs, even from his fellow Serbs. Such actions of Ratko Mladić do not evidence a genocidal criminal intent. Rather, they suggest an interpretation consistent with reasonable doubt of an honorable soldier trying to save lives and protect all the people of his country, even non-Serbs, in a very difficult and perilous war. Your Honors, that is enough for an acquittal. The prosecution is nowhere near the top of the pyramid with such evidence. Further, again, I don't know how much detail I'll be able to go into next week on the municipalities, but one has to look at the manner in which General Mladić's VRS forces were engaged in the very municipalities where the prosecution alleges genocide. If we can have the next slide, please. I will look at Ključ right now. Exhibit P3923 is excerpted on our screens right now, and it was presented by the prosecution at trial and was submitted to try and show that VRS forces were in villages and areas that were scheduled indictment incidents. It was used with witness Kivac. The prosecution's only concern was to demonstrate that the VRS was present. For them, this was enough, because by the prosecution's view, the VRS is a criminal entity. Again, for them, being a Serb is a criminal offense too. Therefore, the prosecution chose not to focus on what the VRS actually was ordered to do and what it actually did. The prosecution ignores the presence of armed enemy combatants of the ABIH side or their activities, which necessitated military clearing operations or czyszczenie. So as to a wide area in Cluj on 30 May 1992, which is this entry in this logbook, mopping up or czyszczenie was performed to address Bosnian Muslim forces who were armed and active. And now let's look at the results of that action. Results. Arrested 250 people who surrendered their weapons. After investigation, 100 were released to go home. That doesn't sound like genocide. Next entry. About 1,000 refugees in the village of Ljusha were allowed to return home after a search of nearby villages. Again, that doesn't sound like genocide. Witness Kivats testified that this is consistent with the way the JNA and VRS conducted mopping up or czyszczenie operations. And that's at transcript page 30541 to 30544. Again, Your Honors, this evidence does not support a finding of any discriminatory intent or any genocide.
Mr. Mladić, I'm
Yes.
looking at the clock. We're close to the moment where we have to adjourn.
If I could just perhaps have 20 seconds to finish this paragraph, it'll be
20
easier.
seconds you have.
This supports a finding of legitimate military actions aimed only against the armed enemy combatants. Why else would some people with guns be allowed to go home? Because they were found not to have used their weapons, not to have posed a threat. And if a temporary removal of the civilian population during mopping up or combat is followed by a return of these civilians to their homes, well, there is only one result that can be reached under law. That's an acquittal. And I thank you, Your Honors.
Thank you, Mr. Mladić. Before we adjourn, I would have one or two small questions for you. Only a few minutes ago, you referred to D929 and D1503, and you say these are documents, General Mladić's documents issued in September and October of 1995. I can follow that for D1503, but D929 seems to me to be a witness statement rather than a document issued in September. Mladić document. Further, could I ask you, in transcript page 67 today, you refer to your final briefs, paragraphs 2262, 2263, and 2264, and you did so after you said we would now turn to Srebrenica. 2264 deals with modified air bombs, which are really a Sarajevo issue, and 2262 and 2263 seem to give comment in the context of the evidence given by Mr. van der Weijden, which also places us very much in the Sarajevo area rather than in Srebrenica. And I'm not blaming you for the speed of speech, but of course I can't check everything at this moment. But these are just a few sources where I had difficulties to follow you, not in your speech, but in the underlying documents you refer to. We adjourn for the day, but perhaps may I take it that a response earlier announced will be in writing, and then we'll look at that later today. We adjourn for the day and we'll resume on Monday, the 12th of December, 9:30 in the morning in this same courtroom 1.
All rise. Veuillez vous lever.